Australia series hosted by the Australian Centre at the University of Melbourne. Before I introduce our speaker today, I would like to hand over to our very beloved Auntie Di, or Professor Kerr, as she now is, who is going to welcome us to country. Thanks, Auntie Di.
Thank you, Sarah.
Thank you so much, Auntie Di. It's a real privilege always to have you join us and to welcome us with so much warmth, particularly at a time when I know your community is going through loss after loss and is in so much mourning. It's really special that you can find the time to be with us, but also that you can bring to us those words about not just honouring ancestors, but looking forward and having hope for the future and building that hope and happiness and resilience in the children. So thank you for being able to bring that hope and that joy to us still, even in this time of sadness for you.
Thank you.
Very special. Thank you for being with us. I'm in a moment going to introduce Professor Kirsty Gover, who is our guest this morning. Before I do that, just a couple of quick housekeeping notes that'll be familiar to anyone who's joined one of these webinars before. So you'll note that the chat function is disabled, but that doesn't mean we don't want to hear from you. There'll be time at the end of Kirsty's presentations for some questions, and we'd encourage you to use the Q&A function at the bottom of your screen to type in your questions, and you can do that at any time during Kirsty's presentation as questions occur to you, and at the end of her presentation I will work through some of those questions in the time that we have remaining. So please go ahead whenever you're ready. Okay, but to the main event, which is Professor Kirsty Gover, who's presenting today on Aboriginality and alienage, legal pluralism at the Australian border. For those of you who don't know Kirsty, she is an extraordinarily generous scholar who I'm very privileged to call a colleague. She's a first-generation New Zealander who grew up on Katimamo Ngai Tahu land and is a professor here at Melbourne Law School. She teaches and writes about domestic and international law affecting Indigenous peoples in Canada, New Zealand, Australia, and the United States. And she's currently undertaking an ARC Future Fellowship on Indigenous-settler legal pluralism in those countries. So I'm going to hand over to Kirsty now and make myself disappear, and I'll see you all with some scintillating questions at the end of Kirsty's presentation. Kirsty.
Thanks, Sarah. It's wonderful to be here. I want to thank the Australian Centre for hosting this event, and thanks Sarah and Julia for the invitation to be part of this series, Undoing Australia. And thank you also to Auntie Di for that very powerful welcome to country. I've had the honour and privilege to live on Wurundjeri land now for nearly 13 years. I want to thank Wurundjeri and their elders and ancestors for taking care of this country and looking after everyone on it, and also want to acknowledge the authority of their law in this place. So in broad terms, as a settler scholar, a central aim of my research and writing is to take up the challenge posed to settler legal systems by Indigenous law and Indigenous legal theories, and to think through the ways that settler officials, settler scholars, and the rest of us, for that matter, should respond to these challenges in an appropriate and just way. And these challenges are substantial. They will require, I think, us to think and rethink through our own traditions of constitutionalism, sovereignty, and of the nature and source of law itself. But I believe, as many of you in this room no doubt do, that settler colonialism is a power structure that is bad for all of us one way or another, and that we will all benefit intellectually and psychically from Indigenous leadership in this area and in others. My talk today is drawn from work underway with my colleague Mary Spiers Williams, who's a legal scholar at the ANU, where we're looking at the idea of country with a capital C as constitution. And some of what I put before you today is drawn from conversations with Mary and from our joint thinking and writing about these issues. And essentially today's talk will address the emergence in settler law of a new category of rights and interests, new at least to settler law, that are claimed by non-citizen Indigenous people. And these are more or less claims to the right to remain in or to enter the territorial space of a state of which one is not a citizen by virtue of one's connection to traditional lands within or across the territorial boundaries of that state. So there are developments in Australian settler law and also in Canada which ascribe legal and constitutional consequences to the fact that Indigenous people's connection to their lands have survived the superimposition of the state form and state borders over their territories. And one way to think about or situate this line of thinking is to contemplate the fact that Indigenous polities underlie the international order of states. They are much older, they are much more embedded in place than that international order of states, and that there's an increasing recognition in settler law that Indigenous polities are not and cannot be defined by states. Or contained by states. And this is a theme that I think fits very well with that of the Undoing Australia webinar series. And that's why I thought it might be a good one to bring to this forum for your consideration and for our discussion. So today I propose to focus on just one important but quite specific element of this set of ideas, which concerns the status of Aboriginal non-citizens in Australian constitutional law. And I want to invite you all to think along with me about the meaning and the transformative potential of some recent developments, especially, and this is the crux of today's talk, is what we all should make collectively of a recent decision of the Australian High Court handed down in 2020 called Love-Thoms and the Commonwealth. So with that, the Love-Thoms decision, as we call it, gave legal pluralists like me in Australia and elsewhere quite a lot to think about. In a 4-3 split, the High Court recognised that the connection to country that Aboriginal Australians have means they can never be aliens to Australia, as that term is understood in the Australian Constitution. And in practical terms, that means that an Aboriginal Australian can never be deported from this country. And in the Love-Thoms case, Daniel Love and Brendan Thoms, who were born in Papua New Guinea and New Zealand, Aotearoa respectively, and are citizens of those countries, successfully challenged their detention and their proposed deportation on the basis that they are Aboriginal men. In other ways, because of the success of their claims and the High Court's determination, connection to country is a principle with legal consequences in Australian settler law. In fact, in this case, it conditions settler sovereign power to remove Aboriginal people from the continent and islands that we now call Australia. But all 4 judges in the Love-Thoms decision, they also made it clear that their reasoning and their decisions did not compromise the sovereignty of the state, and they did not purport to recognise Indigenous sovereignty. And partly for this reason, when the decision was first published in February 2020, I, along with others, received it with some disappointment. Back in February 2020, when the world as we knew it was still largely intact, I felt that this decision conferred a benefit on a small number of Aboriginal men and their families, while smuggling in and bedding down a truckload of settler sovereignty dogma. I had hoped that this decision would yield something like a common law right to self-government, and it did not do that, at least not in those terms. But over the past 2 years, I have talked about this case a lot with Indigenous colleagues at the Indigenous Law and Justice Centre and elsewhere, and I've listened to Indigenous law people and experts talk about the case. And I now feel that I missed what is most centrally important about this decision, and that is that it's a novel attempt on the part of Australian judges to bring settler sovereignty and country into relationship with one another as the 2 foundational sources of settler and Indigenous lawmaking authority. And that's really my first contention. My second contention is that because of this, the case offers us a glimpse of what a fully developed and lawful legal pluralism might look like in Australia, and it manages to do so without triggering the live wire of settler sovereignty, which the High Court considers to be a non-justiciable issue. And given this importance and the novelty of this, of attention to this relationship, at least on the side of settler law and settler officials. It's even more significant that earlier this year, the Morrison government tried to have the Love-Thoms decision overturned. And this appeal revolved around the fate of Mulunjali man Shane Montgomery. The appeal was withdrawn when the Albanese government came to power as a result of intense Indigenous advocacy. But it remains, in its anatomy, an excellent illustration of what is at stake in these cases and what will be at stake in future cases applying the Love-Thoms precedent. So I'd like to say something about Shane Montgomery's case in a moment. But let me begin my story with an observation about the way that the 4 majority judges on the High Court and Love-Thoms approach the idea of country and connection to country in their reasoning. So the judges, all non-Indigenous, as you no doubt knew, they speak in various idioms about the legal consequences of connection to country, but they don't attempt to classify this connection using settler legal terminology. When you look to find the content of connection to country in the reasons of the judgment, it's evident that it is not a common law right. It's not treated as a set of facts capable of yielding common law rights, and that would be the native title prism. It's not described as traditional law and custom, although its meaning by implication is expressed via traditional law and custom. So it's not a set of rules, it's not a set of norms, it's not exactly a set of laws, but it might be the source of and repository and vehicle for Indigenous law. And critically, as I've said, it's not sovereignty. So accordingly, some of the significance of the judicial discussion in Love-Thoms is that connection to country and country itself seems to have escaped and evaded the categories that settler law in Australia and elsewhere have used historically to manage the slim and quite precarious interface with Indigenous law and legal systems. And I think this is very striking. And it's this part of the judgment that I would like to reflect on today. But I want to say at the outset that I have no direct or insider knowledge of what country is or contains as an Indigenous concept. My focus is on the relationship at stake and on what country, as I come to understand it and learn more about it, might require of settler law and of settlers. And in particular, I feel that a major responsibility we have as settler lawyers and scholars to country is to resist the temptation to give in to our cultural and legal obsession with discerning and finding finer and finer points of law in pursuit of more and more precision and detail and comprehensivity. And all of that, after all, is the pursuit of analytic certainty. And this, I can imagine, might be a virtue in some contexts, but I feel it does not serve our relationship to country, and it does not serve the relationship that settler law has with traditional authority. And when Mary and I were speaking about this, as we often do, both of us are huge fans of Billy Bragg, who some of you will know if you're of the correct vintage, is a folk and protest singer from the north of England, who everyone that I knew loved in the early 90s and late 80s for that matter. And in one of his best loved songs, Billy Bragg says, "We must resist the temptation to take the precious things we have apart to see how they work, because," he says, "they never fit together again." And I think it will not be lost on any of you that this propensity to pull precious things apart in pursuit of certainty is exactly what the Morrison government purported to do to the Aboriginal families and peoples of the men it proposed to deport. However, the fact that country has retained its integrity when viewed and expressed through the judicial lens of Australia's highest court, I think that's important and a progressive move. And I want to draw our attention to this judicial appreciation of country, not as a fully developed theoretical model, because it's not, but as something like glimmers of light, perhaps showing that the uncertainty that comes with legal pluralism is tolerable if, on the settler side, we can also be okay with not knowing everything all at once. And I'm reminded here, of course, of what Auntie Di said in her wonderful Welcome to Country. So, Although they describe the connection to country in slightly different ways, all four majority judges referred in their reasons to a 1979 case called Millipum and Nabalco. And some of you may know that case as the Gove land rights case, a tremendously important landmark in Australia's settler legal history. In that case, Justice Blackburn said that the law of the Yirrkala clans, whose evidence he was hearing, showed that, quote, the fundamental truth about their relationship to the land is that there is an unquestioned scheme of things in which the spirit ancestors, the people of the clan, particular land, and everything that exists on it and in it are organic parts of one indissoluble whole. Now, the scheme of things was referred to by the judges in the Love-Thoms case as entailing a connection that is, quote, older and deeper than the Australian Constitution, which reveals the deeper truth of Mabo number 2, namely, quote, that this connection to country was not severed or extinguished by European settlement, which is in quotes, nor by the assertion of sovereignty, nor by federation, nor by anything that happened after federation. And in the words of one of the judges, to classify any member of an Aboriginal society as an alien would be, quote, to recognise that the Crown had the power to tear the organic whole of a society asunder, when in fact recognition of the connection means that, and this is another quote, the sovereign power of this nation does not extend to the exclusion of the Indigenous inhabitants from the Australian community. At the same time, as I noted before, as emphasising the recognition of country and country itself, the judges are emphatic that none of this is to accept that Indigenous peoples have their own sovereignty or that the state's sovereignty is compromised. But I now see that, notwithstanding the fact that state sovereignty is purportedly left intact, so also country is left intact. In fact, we're offered a glimpse of country here through a cracked door. Or, as Mary has said to me, a glimpse of country through the brittle overlay of settler law and sovereignty, those cracks being put there by country itself in the process of asserting itself and its authority, which it always will do. Country will grow through and over settler law and all of our other human enterprises and conceits. And as Mary's co-teacher, Warlpiri philosopher Wanta Patrick said to the two of us earlier in the year when we were meeting with him, he said, humans didn't come up with the law came up with us. So even having left connection to country to stand sort of out there, more or less on its own terms, the High Court was nonetheless compelled to ask a question about humans. They had to ask, who are the humans who, through their connections to country, are Aboriginal Australians? And this engages, obviously, questions of law, but also questions of legal pluralism. Who decides whether a person is an Aboriginal Australian? Is it the Indigenous peoples and their legal systems, or is it the state and settler law? And this question, dropping down into a more concrete legal dispute before the court, to my mind, sort of transforms this legal, this arm's length encounter between sovereignty and country into something that looks a little bit more like perhaps a Venn diagram, or perhaps more accurately like a dovetail joint. It asks the question of which law should govern which people with respect to which issues on which land. That's a jurisdictional question. And the majority answered the question of who is an Aboriginal Australian by reference to the so-called tripartite test that was set out by Justice Brennan in Mabo number 2, and that reads as follows. Membership of the Indigenous peoples depends on biological descent from the Indigenous people and on mutual recognition of a particular person's membership by that person and by elders or other persons enjoying traditional authority among those people. The question then on everyone's mind, or at least on people who think about this relationship in jurisdictional terms as I do, is the recognition of a person's membership by persons exercising traditional authority effectively the exercise of Indigenous lawmaking authority? Is that what's being recognised here? And significantly, who gets to decide what biological descent means? And this part became critically important in the Montgomery appeal, because Shane Montgomery was culturally adopted into an Indigenous community, into the Malanjali people, whose traditional territory is up on the Gold Coast. Montgomery does not have, or he does not know if he has, biological Aboriginal ancestors. And to think through the import of this, it will be necessary, I think, just to say a little bit about Shane Montgomery's circumstances, so we can see the legal pluralism at play here that's underpinning the concrete dispute. So Shane Montgomery is a New Zealand citizen, born in New Zealand. He's not an Australian citizen. He has Māori ancestry through his father, who's a Ngāpuhi man. And in the late 90s, as a 15-year-old, he entered Australia and was granted a visa, as all New Zealanders are automatically when they enter Australia. And in the years after he arrived, he became homeless. He was placed in a shelter for young Aboriginal men and was later taken in by a Malanjali family, eventually being initiated into the Malanjali community, he and his family say, by participating in the relevant ceremonies on country. He had many encounters with the police as an adult, mainly with respect to property crimes. And in 2018, he was sentenced to a term of imprisonment of 14 years, so that his visa was automatically cancelled according to Australian migration law. Then he was placed in immigration detention, and the Commonwealth took steps to start progressing his deportation back to Aotearoa, New Zealand. He was still in detention in 2020 when the High Court decided Love-Thoms. And so he went to the federal court arguing that he should be released because he's an Aboriginal man. Now, in his affidavits, and I think it's important to hear his affidavits in his voice, this is what he says about himself. He says, I identify as Aboriginal. I have been accepted as such by the Malanjali clan of the Yungambeh people of South Queensland. I was reared up within the Malanjali people and initiated at Bow Desert, our country. I am a Malanjali man. I do not need to have a biological Aboriginal ancestor to be Aboriginal according to the traditional laws and customs of the Malanjali people. This is the decision of the elders in my family. I am an Aboriginal man, and this is my country. When he was pressed by immigration officials to supply information about his biological descent, he told them that he had been told by his Maori relatives that his New Zealand Maori family, the Ngāpuhi people, had married into an Aboriginal clan some generations back. But he said, I do not know if I am directly descended from Aboriginal ancestors. And he was supported in his self-identity by Malanjali elders who provided affidavits to support his claim. And one of them, which I think is illustrative, says this: Shane's bloodline is Malanjali, and he was brought into this by being reared up by our family. He was taught our ways, and he's one of us now. He belongs to this country now. The judge hearing his case decided that it was reasonable to think that the Love-Thoms precedent could support Mr. Montgomery's claim that he was a biological descendant of Aboriginal people by traditional law and custom. Therefore, she held he could not be detained and he was released. And it was his release and the decision ordering his release that the Morrison government wanted to appeal to the High Court. So in their arguments in the Montgomery appeal, the Commonwealth reiterated some of the concerns that the minority judges had had in the Love-Thoms case. So they said that deferring to the membership decisions of an Aboriginal community on membership would amount to an impermissible concession that that community held sovereignty. They insisted that the key criterion of Aboriginality is biological descent, and insisted that that entailed a genetic relationship with an Aboriginal person. They also made a claim about uncertainty, which they say relates to the difficulty of settler officials understanding Indigenous law. And they say if biological descent doesn't decide this matter, then recourse would have to be had to traditional law and custom governing adoption. And that, they say, would vary between Aboriginal societies, possibly even within societies, so that the reach of the government's power could only be ascertained by matters specific to particular Aboriginal societies, being matters that are, quote, difficult to ascertain and may vary over time. Now, because of the Commonwealth's argument, everybody that I know was relieved, very relieved, that the appeal was eventually withdrawn. But I think in this particular case at hand, if it were to arise again, and we do need to contemplate that possibility as a serious one, the fact that judges in the High Court were prepared to reference connection to country in terms that they suggest they understand it as a source of Indigenous law, and especially that they described it as a principle older and deeper than the Australian Constitution, opens up the possibility of a pluralism of legal theory, that is, pluralism of conceptions of what law is and where it comes from, not just a pluralism of laws themselves. And so the great potential I see in judicial references to country and connection to country then is that they enable Indigenous legal theories to help reconstitute the relationship between Indigenous and settler legal systems. And I think that's very, very necessarily and vitally important. And here I draw on Mary's recent work, which she discusses some basic precepts of Indigenous law. And she says, forcing first law into compartments diminishes first law. We have an obligation, she says, to avoid, quote, examining Aboriginal laws through the prism of colonising state law in order to fit it into its compartments, to slot it, is her words, I'm sorry, to slot it into its compartments. And this is important because in Love-Thoms, I think country has not been shoehorned into or excluded from settler legal categories and taxonomy. And this, I think, means it retains a lot of its transformative and constitutive power. In addition, and crucially to my mind, country, as I'm coming to understand it and what I have learned, especially from Mary, but also from others, country carries with it theories of pluralism and relationship that sovereignty lacks. So Dr. Christine Black, a Commonwealth woman and legal scholar, has said, quote, Indigenous law is above all a law of relationship. And Mary has written that responsibility to country entails relationships based on what she calls relational autonomy. And again, I'm thinking of what Auntie Di said in her welcome. So Mary says, quote, the unique responsibility of each person in our most fundamental relationship with country means we respect the autonomy of others. It is from this we derive our authority as First Peoples, both collectively and individually. She also makes the point that, quote, authority is the obligation to fulfill our role in the network of relations that constitutes our home. So, from what I have read and heard from Indigenous legal theorists and scholars about country, that's striking that unlike sovereignty, Indigenous conceptions of authority don't aspire to occupy an entire field with one singular source or expression of power, but instead strive to strike the right balance between different authorities through the maintenance of good relationships, because these concepts of authority aspire to do what is right by country. In other words, I think traditional authority can supply terms of engagement that are suitable for managing the relationship between sovereignty and country in a way that sovereignty alone cannot. So, and this is my final set of points. I acknowledge that this shifted thinking can be challenging for all of us who've not grown up with Indigenous epistemologies and knowledge. And on that note, I wanted to point out one thing that I have noticed that may distinguish Indigenous legal theoretical thinking from mainstream settler theories, and that is its emphasis in Indigenous legal traditions and theory on the individual's responsibility to develop the appropriate attitude or affect relative to law. And here I have in mind Christine Black's brilliant work on appropriate feeling with law, in which she tells us to feel the law which is posited in the land requires a communication with the unseen. The feeling of the spirit world and the reliance on that feeling as the basis of knowledge keeps the individual mindful of his own actions and so leads him to internalize the law, rendering it intimate, in contrast to the West's reliance on external prompts and norms. And this, I think, is more than just an exhortation to listen. it is, I think, a personal responsibility to engage and to enter into relationships with country and with everyone on it, and especially those responsible for a particular country. And to bring this idea back to the question that was before the High Court about Aboriginality and belonging, and whether or not, whether to displace or defer to traditional authority on membership, and whether biological descent operates as a settler concept that trumps traditional authority, then we could, if judges were willing to take up this kind of deep pluralism, we could have them engaging with types of theories of the kind that Palaku legal philosopher Amber Quire-Mullen has described. And sorry, I want to read what she says about belonging. To be an Aboriginal citizen of an Aboriginal nation is to exist within a network of relationships, the pattern or story of which was laid out by the dreaming ancestors and which is upheld through the law. There may be connections between your own country and another's, for example, through intermarriage or song lines. But if these connections cannot be determined, strangers are often assigned a place within the kinship system of the nation they have entered. This brings them into the fabric of relationships that comprise that nation and into the right responsibility duality encompassed by those relationships. And I want to note that this set of ideas is echoed and iterated in writing by Indigenous legal theorists and scholars from all around the world, who stress the pervasive importance of kinship as a principle connecting people and peoples to one another and to land and to all the other persons, human, non-human, and superhuman, that constitute the communities in which we live. And to conclude, I also have in mind a galvanizing invitation made recently by UN scholar and barrister Tim Goodwin, who was instrumental in shaping the outcome in Love-Thoms, so to whom we owe a great debt of gratitude, as he was serving as junior counsel for the state of Victoria as intervenor. And it is relevant that in the proceedings, aside from Mr. Love and Mr. Thoms, Tim's was the only Indigenous voice heard. There were no other intervenors. In a speech he gave at the launch of the Melbourne Law School's Indigenous Law and Justice Hub in April this year, he said this: "We must begin to transform our general institutional settings in this country to invest them with indigeneity. It is no longer sufficient to acknowledge the distinctiveness and depth of feeling for country that Aboriginal and Torres Strait Islanders have only in the abstract." So, two final points to take up. The invitation from Tim, from Mary, and other scholars like Christine Black. Viewed through the lens of country as a balancing corrective to the excesses of sovereignty, I think requires those of us who work in and are responsible for settler law to be attentive always to mutuality, to Indigenous assessments of the lawfulness of settler law. And with this in mind, and acknowledging that I am an outsider to Indigenous legal systems, I think it would be unlawful for settler law and sovereignty to sever a person's connection with country, where country, including the people responsible for it, have said that that relationship is correct and requires maintenance. And it would also be unlawful, I think, for settler law and its people to continue to position itself and themselves as not in nor in need of a proper relationship with country. Thank you.
Kirsty, thank you so much. Love the little applause emojis floating up at the bottom of my screen. I hope you can see those. As always, you know, as a non-lawyer, whenever I listen to you, I'm absolutely mesmerized because you make the law so engaging and so interesting. I also want to note that you are the first in our CPC presenters to reference the great Billy Bragg. I am a person of a certain age, and so Billy is dear to my heart. I believe I cried the first time I left one of his live gigs because I didn't want to go home unless I could take him with me. So thank you for that. But you know, your work engages, and just a reminder to people, please use the Q&A function to send through your questions. Your presentation just now reminds me of, you know, I think one of the the challenges that First Nations in this continent and other settler colonies face all the time, which is around this settler obsession with certainty and with singularity. And I think, you know, you didn't mention capitalism, but I do think that capitalism is integral to particularly to the rationale for this obsession with certainty. And you contrast that, you know, drawing on important Indigenous scholarship to highlight you know, the Indigenous attention to responsibility, to relationality, and a more, I don't want to use the word like natural, but that, you know, a deeply ingrained commitment to plurality, to pluralism that is embedded in Indigenous cultures. You don't share a continent with several hundred First Nations peaceably and responsibly and lawfully without accepting that plurality is just a part of the deal. And I think what you're saying is that in these recent legal judgments, there seems to be maybe a slight cracking open of the legal system's attachment to certainty and the political pushback to that. I'm wondering, I mean, I have many questions, but I'm wondering how far you see that cracking open, like how far can we crack that open without not just a political pushback, but the kind of the pushback of capital that we saw, you know, in the wake of the Mabo decision, the kind of fear mongering around what pluralism might mean in relation to certainty for capital. How do you observe that tension playing out in your work?
Yeah, and I think that's obviously a great question. So I've got a couple of responses. So one is about Indigenous advocacy and expert strategy in dealing with all three branches of settler governments at every level of the Federation. So we can see that the courts are just one theatre for this kind of advocacy, and possibly the ones who think of themselves as more limited in their capacity to make systemic change. So I want to acknowledge that. But we also can see all of the work that's going on engaging the executive and the legislature at state and federal level with the treaty process, which is incredibly important, and also with efforts to enshrine some of the proposals in the Uluru Statement. So I think it's a multi-level approach. That said, thinking about what the judiciary as a branch can do and what judges as a particular variety of settler official can do, one of the things that I've been, excuse me, I just have to pick my dog up or he'll start barking. One of the things that I think is promising is that there are tools and methodologies, and this is, I think, part of how I position myself as a legal scholar. There are tools and methodologies within settler law that can help to manage the relationship in a way that does not require everything to be dissected and sort of set out or sealed in amber for examination. That's a statement from one of the judges in the lower court, actually, which I think is very promising. I can come back to that, but let me put this this idea forward. So it is very normal for Australian courts, as it is for courts in other parts of the Commonwealth fraternity, to apply the law of foreign states to resolve issues that involve the application of foreign law, and indeed, as we all know from the Canavan controversy and other instances, to resolve questions of status. So there is a method for looking at the law of a foreign state and applying it to resolve a question of status. And most importantly, I think when that happens, and that's called conflict of laws or a choice of law or private international law, there's no question about whether the state's sovereignty is compromised by that exercise. In fact, it's understood to be an expression of sovereignty. So I think there we have a conceptual analogue that could be brought to bear. And I think that could be enormously helpful. And I think what the High Court has done, and you phrased this well, is just to open up the possibility that there is a source of lawful legal authority that does not derive from the state. And that may seem intuitive because, as a matter of fact, of course, we all know that Indigenous law exists and it governs the lives of Indigenous community and it's a source of normative obligation. But for the High Court to even entertain that possibility is novel and important. So I feel optimistic. I mean, I am an optimist. I think capitalism has atomized us and divorced us from our communities and reduced our sense of ourselves as being connected to one another. So I appreciate your point on that too.
I will take a couple of questions that are coming in on the Q&A in a moment, but I just want to go one step further with that, because I've heard you speak on this before, which has, been very powerful for those audiences, which is, in the same move as the High Court is maybe cracking open these spaces, they continue to set aside the question of sovereignty, of Indigenous sovereignties, as saying that's outside of our remit. We can't address that fact because basically because we are a creation of a sovereign settler order as the court understands themselves. And so, and yet from an Indigenous perspective, like the connection between sovereignty, the idea of sovereignty and country is indivisible. That's where, sovereignty comes up from country through people to be expressed and lived in the world. So I wonder what you think about that kind of double move from the court there, that on the one hand, they're saying sovereignty over there, can't talk about that, but country, is this a way through a legal and political impasse, do you think?
That's what I hope. Now, as always, the decisions from courts are often written in ways that are closer to art than science. So there's plenty of room for interpretation. And I suppose that it is certainly possible that this has provided, at least for the majority judges, a way to think about the relationship, which doesn't trigger the non-justiciability issue in the same way. Now, of course, there's a huge range of opinions about the terminology that should or should not be used to describe Indigenous lawmaking authority. But I think really what it may come down to in many instances is this question of domination or subordination. If we can deal with that, if we can approach one another in conditions that are of equality, then the terminology becomes less important. So it may be that with jurisdictional thinking, settler officials, including judges, can come to understand that Indigenous lawmaking authority over the country that traditional owners are responsible for and for the people that they are responsible for is compatible with a version of settler state sovereignty, and that it can be secured without triggering too much in the way of constitutional collapse.
I love your optimism. Let's hang on to that. Okay, to a question now. It's not quite phrased as a question, but I think there's a question lurking in there. So Heather says that, it's unlawful to intervene with the maintenance of country. However, at the core of this is how Western cultural heritage laws intervene as they generally endorse prioritising Western control, and they draw attention to the Rio Tinto case and the destruction of Juukan Gorge. So there's a deep just double standard in there in the way that the law navigates those questions. Have you got any reflections on that?
Yeah, I mean, obviously that's a tragedy, and it does draw attention to the fact that this is just a flicker of light, and that there's so much more to be said about a pluralism that can recognise Indigenous authority in its fully fledged and thriving capacities. I will say that this is exactly the kind of thing that I think we can draw attention to in the way that we think about settler law, by understanding that recognition is and non-recognition for that matter is reciprocal. So what I've heard people who are practitioners or theorists of Indigenous law, that a lot of settler law would be considered unlawful or not law at all, perhaps, by Indigenous communities and First Nations, if it does not maintain a correct relationship with country. And that's what I think about when I hear about instances like the Juukan Gorge incident. is that these things may be, for First Nations, they're almost certainly illegal acts.
Absolutely.
No matter what settler law says about it.
Absolutely.
So developing a more perspectival and more, I don't want to use subjective because it's not quite the right word when you're thinking about nations, but understanding that there are many ways to look at this relationship, and that the most apt ways are not coming from the state, in my opinion. They're coming from the long experience of Indigenous First Nations and managing their relationships as international relationships for thousands and thousands of years. We would do well to pay attention to that and its stability and longevity, and take it very seriously.
Yeah, I think we're starting to have something of a conversation about that publicly in the wake of, the evident climate disaster that is not just looming, it's happening.
Yeah.
And, some belated recognition that perhaps part of being in a correct relationship with country actually means, living in ways that don't intensify, that don't turn our continent into a place of fire and flood that is going to be increasingly unlivable for numbers of people. That's something that didn't happen prior to settler occupation. And if I'm optimistic about anything, it's that perhaps at least the people living through those impacts will start to reflect differently on how we might all live differently on country in a way that recognises our responsibilities to one another and to country. But
yeah, if I could just add something there, because this relates to some of the work that Mary and I are doing at the moment. I think those ideas are also enhanced, those ideas of responsibility to land are enhanced by the idea of country as polity, that it's populated, it's living, that the humans are not the creators of law. They're certainly not the necessarily most important people in that legal system or in that polity. And that sort of diminishes this expectation that everything is there for us to exploit. And I think that's important. I think we can see that in the way that First Nations manage their relationships with one another and with land. It's very instructive.
Another question here. I'm not sure if you'll be able to speak to this particular case, but someone asks that nations like Yidinji have been attempting to have the conversation with the settler legal entity. Are they on the right path?
Yeah. Yes. So, I mean, when you take like sort of if you pan back and you look at the range and diversity of First Nations efforts to engage settler governments, it's extraordinary and tireless. Like it's so impressive. So I think it would be a mistake for all of us to hang all of our hopes on the High Court. I think what we can expect of our judges as a sort of senior law people is that their thinking and explanations of the relationship is important, and we can take some of that, some of those advances when they're progressive and when they support a proper relationship, and sort of use them in advocacy and strategies outside of the court. And that I think is the great potential of judicial statements like the ones that we saw in Love-Thoms, is that they really are conceptually framing commentary that has huge authority in the settler legal system and has applications outside of just the matter at hand. And that I think is another reason why we're also relieved that the Montgomery appeal wasn't pursued, because we stood to lose an opportunity to further develop these ideas in courts and outside of courts. So I think, yes, that type of reasoning can be used by First Nations, and I'm sure it will be, in their sort of ongoing and expert engagement with local, state and federal governments. I'm sure of it.
We've got time to sneak in one last question before we wrap up. So another attendee today asks, if drawing on other legal authorities can be an act of sovereignty, as you say, is there the risk that opening up to Indigenous laws will be used to reinforce rather than challenge the legitimacy of the settler state law?
Yes, it's a really great question. So there is a lively debate going on about conflicts of laws and choice of law principles and legal pluralism, which is broadly the field that I work in. And some people do worry about the idea, well, first of all, the idea of equating Indigenous law with foreign law. That is optically and conceptually difficult because Indigenous law is the first law. I see it as that a better analogue is, well, these are legal systems that are foreign to one another. Clearly, settler law is the foreign legal system in the settler states. There's also the ongoing risk that when put in the hands of settler judges, that their own conceptions of law and its meaning will be sort of smuggled in or inveigled into Indigenous concepts of law. I accept that that is a risk. So I think, again, it's incumbent on all of us to make the very best arguments that we can to prevent that from happening, so that Indigenous expertise and Indigenous knowledge and leadership is at the forefront in these communications, and that it's given its proper place. So yes, it is a risk. It's a risk across the board because we're in a situation where we've got one legal system asserting dominance over others. That's a straight up and down power imbalance. So all of those things will attend all of these relational endeavours, and we just need to be, well, not just because it's not easy, but we need to be very attentive to the downsides of engagement. Yeah.
Kirsty, thank you so much. Some hope, some notes of caution, an extraordinary capacity to make the law interesting and genuinely engaging. Very, very grateful for your contribution today to the Undoing Australia webinar series. Before we wrap up, I just want to spruik the next couple of events we have coming up in October, a busy month for us in the Australian Centre. So on the 13th of October, we have a special event, Hemo Parecki Simon and Lorenzo Veracini, in conversation, musings and reflections on Indigenous politics and settler colonialism in Aotearoa, New Zealand. And then on the 26th of October, we have our final CPC, Critical Public Conversation of the Year, with the wonderful Kevin Brunel speaking on his book, Settler Memory, and that's on the 26th of October. If you haven't signed on to our newsletter, please do. You'll get all the information there, but you can otherwise go to our website and find a link to register for either of those or both of those events. We would love to have you along. Kirsty, an absolute delight as always to have you as a colleague and to get a little bit of access to your giant brain. Thank you very much.
Well, thanks to everyone for coming along, and thanks for the opportunity to think these things through. It's always an opportunity I'm happy to take up. Thanks
so much, Kirsty.
Okay.
Goodbye, everyone. Thanks for coming.